Today let's go over two things that only a top lawyer is going to tell you about your Owings Mills Reisterstown automobile accident case. And I came to these two things after looking at what happened in this past week in a decision that came down from our Maryland Court of Appeals. The Maryland Court of Appeals in the past week in the Coleman case basically upheld a long doctrine in the state of contributory negligence. Contributory negligence is something that basically finds that if you're 1% at fault in an accident, you can't recover. Many states in our country do not recognize the doctrine of contributory negligence, but we do. And understanding that we do is something that all trial lawyers must just grin and bear it and must deal with. And it amazes us at this point when we look at it and we look at Coleman and we look at what happened in the Sun, some of the trial lawyers' reactions to this case. And it kind of shows us that a lot of people who are doing personal injury law in the state of Maryland basically don't understand how to act within the confines of this particular law. In fact, one of the lawyers who was even involved in this case said basically that the decision of this court is a surprise and that it shows that the court's not sophisticated and that shows that this court misunderstands state politics. All that's not true. The decision, in fact, was 5-2 in favor of the doctrine of contributory negligence. Our court's plenty sophisticated. What it shows is basically our court says to people out there that if you're involved in an accident, you sure better find a lawyer who understands this doctrine. In other words, you are 1% at fault. If you're 1% at fault, you can't recover. Find a lawyer that has the resources and the understanding of this law to handle that and to protect you, to make sure you don't give statements if you're involved in an accident to the insurance company, to make sure you don't waiver or deal in any way directly with an insurance adjuster who is trained about this law and is trained to look at this exact decision to try to destroy your claim. The second thing is basically simple. You have the burden of proof. After you get over the hurdle of contributory negligence, you have the burden of proof. In other words, you have to be able to show 51% to 49% that the case is in your favor, that the evidence is in your favor. If you waver on that, or if the scales of justice are even, you lose. So find a law firm that has the resources to go out and look at the light sequences, to obtain witnesses, to get what you need to get a fair recovery.